Thank you very much. Thanks for this opportunity given to me by Madam and in particular by my dear friend Paolo. And when I say that I am really grateful for the opportunity, I mean it, that this is an opportunity where I can share with you or can invite you to think through possibilities of returning to the rule of law when the rule of law was threatened or was demised by destructing the independence of courts. This is a general problem that exists and a problem that is difficult to tackle because of what we all cherish, judicial irremovability. A return to the rule of law where the rule of law was attacked by courts may run into this fundamental principle of irremovability. Now, there is a workaround here, and that is to say that when you would like to remove a judge, you remove him not because what he did as a judge, but because the appointment was inappropriate, a wrongful appointment. So the question will be whether the appointment itself was appropriate or not. At this point, I am in a privileged position that Paolo already shared with you the fundamentals of the position of the European Court of Human Rights regarding the Icelandic case, Anderson. But I would like to select a few words from the principle that was mentioned there. It's true that in that case, the fundamental consideration in the cumulative criteria was that there was a manifest breach of domestic law that must be objectively and genuinely identifiable. Now here comes something that might be relevant for this situation that I have in mind. The absence of such a breach, the absence, does not rule out the possibility of a violation, since a procedure that is, I emphasize, seemingly in compliance with the rules may nevertheless produce results that are incompatible with the above object and purpose, meaning impartiality. And then again, the other criteria again insist upon being in conformity with the very purpose of the appointment. So if the purpose is bypassed, if there is cheating upon the purpose, then perhaps under this test, the appointment is not appropriate. So how to evaluate those situations? Again, the court was of the view that the violation has to be objectively and genuinely identifiable. And then, in particular, when the evaluation takes place, a fair and proportionate balance has to be struck to determine whether there was a pressing need of a substantial and compelling character justifying departure from the competing principles of legal certainty and irremovability of judges as relevant in the particular circumstances of the case. This part, relevant in the particular circumstances case, is probably problematic from a rule of law perspective. You really need guidance what is relevant in circumstances, but leave that aside. We have to live in a world of reality where content is everything. There is one more important element here, which complicates the whole situation. The court said, with the passage of time, the preservation of legal certainty would carry increasing weight in the balancing exercise. So if you are an improperly elected, appointed judge, with the passing of time, you will become a judge. That sounds strange, but this is, again, something that is not unheard of in a rule of law world. Think about statute of limitations. Time is a cure. It is accepted. Now I invite you to participate in this exercise of restoring the rule of law in this area of judicial lack of independence. What to do with the judges or institutions which undermined the necessary trust in the European Union, or what to do with judges who were instrumental in the abuse of fundamental rights. The European Convention has an article, Article 17, which prohibits, in a way, it says it's a little bit complicated, but anyway, Article 17 is about abuse of rights. The court uses that all the time regarding applicants, but the Convention says that it applies to states as well. Now, the court hardly ever used that part of Article 17. So we still have a difficulty finding a state on that basis to be in systematic and systemic violation of the Convention or perhaps other systems of international law. So the remedy to this improper nomination and appointment is often blocked by considerations of irremovability, especially where there is no evidence that the judge was corrupt. Irremovability is based on an individual behavior. But here we are talking about courts as such, full of rotten apples, or just not full of rotten apples, but doing something that is abusive. What are then the compelling reasons that enable departure from irremovability, and how to prove the existence of that compelling reason? According to the court, as in all cases where fundamental principles of the Convention come into conflict, a balance must be struck in such instances to determine whether there is a pressing need of substantial and compelling character justifying the departure from the principles of legal certainty. So once again, the court does allow departure from legal certainty. Just the question is when. Irremovability remains an obstacle to the restoration of the rule of law. When judges were appointed with the decisive participation of a constitutional body that was created in violation of the rule of law, the situation is relatively simple. That appointment may be declared void. So it is not clear what will be the consequence of such voidness if it affects potentially a large number of judges and judgments, undermining legal certainty, legitimate expectations, including those of improperly appointed judges who were appointed not because of their own fault, but because of the fault of the system. And not to speak of the practical impact of all this on the administration of justice, where you generate thousands and thousands of situations where the final judgment is considered to be illegal. Are you going to reopen? I think that was one of the reasons why the court, in that case, was rather reluctant to go into special remedies. Now, this problem is not limited to countries we mentioned. This comes up within the Council of Europe in Turkey, with appointment of judges who were appointed in very specific circumstances. In a way, all these appointments so far were met with eyes wide open in Strasbourg and in Luxembourg. The case of the Polish judges is relatively simple. I emphasize relatively here. But what about appointments where the appointment followed specific rules of appointment literally, where the appointment is impeccable because it is in conformity with the law that is in place, except that the law was changed before the appointment took place. I think there is an answer to that in the case law of the European Court. Although prima facie the Icelandic case criteria is not satisfied because the appointment is in accordance with law, but there are some additional considerations. First one was mentioned by the Venice Commission. The Venice Commission is now of the view that allowing different changing parliamentary majorities to elect judges of one tendency or another better reflects the changing political and societal views of society. Why is that important? Because if all the judges or the overwhelming majority of an apex court is exclusively elected by a single party, you may have a certain doubt about the validity of that composition, given that it is not reflecting the plurality expected by the appointment procedure. I emphasize of apex courts, which are to some extent, or to a very great extent, political. Imagine a situation where the majority changed the rules of election of constitutional judges, moving from co-decision with the opposition to a supermajority solution where there is already a supermajority. So it is clear that the rule is created to enable the government to appoint the judges. What if this is accompanied with a court packing? Court packing is not necessarily contrary to any of the rules of judicial independence. And still, it may fundamentally change a composition of an apex court. So the bottom line is, are these judges removable? The first answer is no, because removal is appropriate only if it is for cause. And this is not within the recognized grounds, because there's nothing contrary to the law, except that the law is contrary to constitutionalism and the rule of law. That's the problem. Like many principles, this is the view of the European Court, irremovability is not absolute. Compelling reasons may allow departure, of course, if additional criteria are satisfied. The exceptions must be legitimate and compelling, subject to the principle of proportionality. Note further that in this Anderson case, it was stated that upholding the principles of legal certainty and irremovability at all costs may, in certain circumstances, inflict even further harm on the rule of law. So this consideration might be extended from individual appointments to a whole composition. But that didn't happen so far. Remember what Paolo just said a few minutes ago. It can be argued that the system of election that precludes the reflection of changing views of society, again, this is a quote from the Venice Commission, if that's the case, then certain interferences might be legitimate, even if contradicting the standard interpretation of the rule of law. Under the Gudmundur criteria, one can conclude that even in the absence of a manifest breach of domestic law, the absence of such violation does not rule out the possibility of a violation, since a procedure that is seemingly in compliance, you remember that, with the rules may nevertheless produce results. So the emphasis here is on what kind of results are produced. That, according to the court, might be a consideration for finding a lack of proper removal. I'm I'm aware of the fact that what I am presenting here is extremely risky. And I'm not 100% sure that this line of reasoning that you can trace in the judgment of the European Court is not leading to its own opposite. It's an extremely risky thing, and similar reasoning was used to undermine the rule of law. So the question is this a proper way to restore it? I leave this question open. My only intention was to confront you with a genuine problem, the problem of restoration of the rule of law. I know that this is not even this is certainly not a recipe. It's not food for thought. It's only a sanitary consideration when you prepare your food for thought. And of course, it's not a most attractive recipe if it were a recipe. So the only thing I can suggest you to have a very good digestive if you take this kind of food, or given that we are in Portugal, I suggest you to enjoy a nice Portuguese porto wine. So on that note, thank you very much. And